Welcome back to this week's episode of The Emily Show, where I can keep you up to date on things that are going on in the law, not in the Karen Read trial. For all of you following along with that, going into week 4 with me and on the Quick Bits channel, thank you. This week on the podcast, we're covering Kouri Richins, the woman who wrote a children's book about grief after her husband passed and then was charged with his murder in Utah. She has a new legal team, but there was a lot of litigation leading right up to her lawyers exiting the case today. And Alec Bladwin wants his indictment thrown out. The judge is going to rule this week. But after an extensive hearing last week, we got some insights as to what the judge might be thinking. So stay tuned. We're going to talk about it. Welcome to The Emily Show. I'm Emily D. Baker, the internet's go-to legal analyst and big fan of the cursey words. I've been a licensed attorney for over 17 years. I'm a former prosecutor, and I break down the legal side of pop culture and entertainment stories we can't stop talking about. We should just get into it. Let's go. Thank you to today's sponsor, Lomi, because sometimes I do not eat all of the food that's in my fridge, and I often feel incredibly guilty about it. With Lomi, you can transform your food scraps into nutrient-rich compost for your garden, houseplants, or yard. Ages ago, Dr. B wanted to start composting in a pile with like worms in it and stuff, and I was not a huge fan. We have had the Lomi in our house long before they became a sponsor because it was a solution that both of us felt good about. It does not stink, which was a huge concern of mine, and he wanted to make sure that we were composting for our yard and garden and putting less food waste into our trash cans, which then makes them stink. Yes, we're very smell avoidant at this household, but it's not just our household because my parents now have a Lomi as well, because I knew that my dad would enjoy it and my mom would appreciate that it does not smell. So if you are ready to reduce the trash you're hauling out to the curb each week, or just looking for a way to repurpose that food, head over to lomi.com/Lawnard and use promo code Lawnard to get $50 off your Lomi. That's $50 off when you head to lomi.com/Lawnard and use promo code Lawnard at checkout. Thank you, Lomi, for sponsoring this episode of The Emily Show. Let's get back to it. Starting with the Rust case and Alec Bladwin, by way of a brief background of what stage in litigation this Rust case is at, Alec Bladwin was originally indicted in the shooting death of Halyna Hutchins. That indictment was subsequently dismissed without prejudice, meaning it could be refiled again. Instead of refiling it, the prosecution, this time the second team of prosecutors, Carrie Morrissey, who you saw in the Hannah Gutierrez retrial, and Jason Lewis, who is now out of the case and has been replaced with a new special prosecutor, took Baldwin's case to grand jury instead of filing charges against him a second time. After he was indicted in January this year, his legal team started fighting the indictment. And that is where we're at now. Alec Baldwin's legal team has been pushing back on the indictment in a number of ways and in some very snappy legal writing. And I have covered Alec Baldwin's team's motion to dismiss, the state's response to that motion, the reply to the state's response, and then the state asking the court to give them one more opportunity to have something to say. It is clear that there is no love lost in these legal teams. Baldwin's team accusing the prosecution of bad faith and more. The legal grounds that they are seeking to overturn the indictment on are multifold, which if you watch the over 2-hour hearing, might have gotten a little lost. It was a very typical court hearing on a motion like this, in that it was very, very in the weeds on the legal theory and on what needs to be proven. And there are some disagreements between the parties on that, but it seems that at least as to what needs to be proven, that the judge, who is the same judge from the Gutierrez Reed trial, sides with the defense on that. The defense is arguing, again, 2 prongs. One, that there were some structural errors, some more fundamental errors in the way that the grand jury was carried out, and that those structural errors require the court to dismiss the indictment. Then on the other prong, they're arguing that there was prosecutorial bad faith, and that allows the court to then look at the sufficiency of the evidence. It is very difficult for a court to find bad faith. I don't think the court will find that here. But that argument, again, grounded in the law, allows the defense to really bring back up everything that they've said this prosecution has done and bring into exhibits their motions for sanctions against the prosecution, accuse the prosecutor of leaking the date of the grand jury to the New York Times, which the prosecutor admitted that she told the New York Times that the date for the grand jury was sometime in November, because from her perspective, that's not a secret. That's just information that all of the witnesses have, the defendant has. And at one point in the hearing, Carrie Morrissey actually said the defendant could give it to his wife's hairdresser. I was like, what is this analogy right now? This hearing got contentious off the bat between two of Baldwin's attorneys and prosecutor Carrie Morrissey. But the judge didn't threaten to take away their coffee, as happened during the Hannah Gutierrez Reed trial. So progress was made. What was funny to me is Luke Nikas, one of the defense attorneys for Alec Baldwin. And remember, the prosecution has accused Baldwin's attorneys of being these big New York City lawyers. And it's not just this prosecutor, the former prosecutor did too. But in the background on the Google Meets for the hearing, he's got a giant New York book, like a coffee table book on his table. I don't know if it was intentionally placed there or if that is where it lives all of the time, but I thought it was kind of hilarious that there was no getting around the New York City lawyer of it all, because much has been made out of it, even though much really doesn't need to be made out of it. But back to this hearing and the merits, the defense went in depth and at length into the different and various case law that they are arguing supports their motion, and factually arguing that the prosecutor cut witnesses off when they were questioned by the grand jurors. Remember, members of a grand jury can ask witnesses questions. They can ask for information. They can ask for more witnesses to be brought in. They can ask for more documents. They have the power of subpoena. And this is one of the fundamental issues that the defense is arguing about, that prosecutor Carrie Morrissey would cut off the witnesses' answers when the grand jurors were asking them questions. And ultimately, this is the argument that the court inquired of the prosecutor on the most. And it seemed that the court's in-depth inquiry into how the prosecutor conducted this grand jury caught the prosecution off guard. Throughout the hearing, the court asked pointed questions to the prosecution and asked, why did you do this way? Why didn't you do this? Did you make witnesses available? Did you contact them? Which led to somewhat of a dust up at the very end of the hearing when the defense said, look, this prosecutor never even contacted the lawyers for some of these witnesses. And the prosecution cut in and said, I am not going to sit here and be accused of being a liar. I never said I contacted the attorneys. I said they were easy to contact, and if we needed the witnesses, we would have them here. I was surprised at the length of the questioning the court went into with regard to how the grand jury was conducted. And multiple times the court tried to point the prosecution to address not just the bad faith, but also address what the defense is arguing are structural errors or somewhat fundamental errors that you don't have to show bad faith to get to. And the prosecution kept arguing they have to show bad faith before they get to anything. And the court is like, no, I disagree that that is the state of the law. If there is structural error, you don't have to find bad faith. So some of those errors, and again, when you think of building a foundation or building a structure, those are fundamental errors that if an error is made there, it cannot stand. So those foundational or structural errors is really where the court focused her inquiry and disagreed with how the prosecutor saw what she needed to prove or what the defense needed to prove, that being the bad faith. And with the amount of questions asked, I am interested to see what the court does when she rules. The court said she is issuing a written ruling on this matter, and that written ruling will be sometime this week. So this is my chance to remind you, if you don't have the Law Nerd app already, at lawnerd.app.com to get it, because when that ruling comes down, I will put an update there first, because of course this is going to happen while we're covering trial. It's a very busy week, and I wouldn't be surprised if this ruling came out later in the day on Friday. But with the amount of questioning there, it's possible that the judge dismisses this indictment. It's possible that the judge finds that the way the prosecutor cut off some of the witnesses' answers to be structural error. What does that mean? Well, the defense made it very clear at the end of their arguments that if the prosecution wanted to take a third crack at this case, they could. I couldn't find anything in New Mexico law either that would preclude prosecutors from either filing charges again and then going to a preliminary hearing, or indicting Alec Baldwin again, or offering him the plea deal that had once been on the table again in lieu of one of the other two, and then filing charges or filing the misdemeanor negligent handling of a weapon that Dave Hall's pled to. And we know Alec Baldwin was offered a plea deal to that as well, and allowing him to plead to the misdemeanor. I don't know if he's inclined to do that at this point, or if his lawyers are just going to fight with the prosecution until the end of time on this. But if the indictment gets dismissed, there is an opportunity for the prosecution to reindict or refile, but it would eliminate the trial date coming up in July and start the process over again. What's clear from all of this is that there is no love lost between these legal teams. Alec Baldwin's attorneys were very well prepared for the hearing, and it seemed that the level of questioning from the court to the prosecutor caught the prosecution off guard. In giving grace to the prosecution, all of this litigation was happening while the Hannah Gutierrez Reed trial was ongoing and winding down. I've said in other coverage of this case that it wouldn't surprise me if Baldwin's team buries the prosecutor in paper, especially while the prosecutor was dealing with other matters that were equally as time sensitive. It will be interesting now that Hannah Gutierrez has been sentenced to 18 months in prison, how this Baldwin matter moves forward, and if this indictment is dismissed, which would be unusual. But with the way the judge was questioning the prosecution, it would not surprise me at this point if that's what happens. Let's talk a bit about Kouri Richins. Thank you to our sponsor, Honeylove. It is almost summer, which means for me, it is hot, sticky season. And the last thing I need is my shapewear and bras to be constricting and moving. I don't want to be pulling things up or pulling things down or fighting to pull things down or fighting to use the restroom. And when I get home at the end of the day or the end of an event, I want to slip into the greatest sleepwear ever. And when I tell you I can't stop talking about the sleepwear from Honeylove, I can't. It is so fantastic. And it keeps me cool at night, which is hugely important to me. When I am going out for events, I love knowing that I am comfortably snatched without feeling restricted in the Superpower short. It smooths, it lifts, and gives you a flawless silhouette under any outfit. Look, we've got curves in the right places. Sometimes we just want to enhance them, not squish them. It's no wonder that the Superpower short is a Honeylove bestseller. The Signature X helps target and sculpt your midsection, and it's gusseted, so going to the bathroom is easy. Plus, you don't have to worry about it rolling down thanks to flexible boning that's hidden in the side seams. So treat yourself to the best bras and shapewear on the market and save 20% off at honeylove.com/lawnerd. Use our exclusive link to get 20% off at honeylove.com/lawnerd. After your purchase, they'll ask you how you found them. Please support The Emily Show and let them know that you're coming from the podcast. The summer vibes are just getting started. It's time to shape your life with Honeylove. Let's get back to today's episode. If the name Kouri Richins sounds familiar to you from other coverage of this case, mostly on YouTube, it's because this case has had so many twists and turns, including a recent update to the indictments in Utah to add a ton of new charges. Kouri Richins is the Utah mom who has now been accused of killing her husband after a previous attempt to poison him with fentanyl failed. In prosecution filings, we have seen quite a lot more information come up about an affair that Kouri Richins was supposedly having, allegations that there were substantial money issues, allegations of messages indicating that Kouri Richins was well aware that she would take nothing in a divorce. The only way under their prenup that she would get any money from her husband is if he died during the course of their marriage. And of course, who can forget the walk the dog letter, which is the subject of some of the litigation that we're going to be talking about today, including Kouri Richins' attorneys, Sky Lazaro, and her entire law firm withdrawing from the case, and the judge granting that motion today as I record this, which is later than I would like it to be on May 20th. The walk the dog letter starts with, quote, "Walk the dog" as the title, but take vague notes so you remember. What we've learned from other filings is that in the video calls Kouri Richins was having with her mother, she would hold up documents or letters to communicate, seemingly with awareness that all of her calls were recorded. We have gone through some of the transcripts of her jail calls that prosecutors filed in connection with this walk the dog letter when prosecutors were indicating to the court that they needed a stay away order between this defendant and witnesses in the case and accused her of witness tampering. But the walk the dog letter was located within her jail cell when it was searched. And it was the prosecution's belief, it seemed, when the jail cell was searched, that this was one of the letters she was showing to her mother during conversation. So the letter says walk the dog across the top and then, but take vague notes so you remember. And the first sentence is, Sky, being the attorney, is saying, even if the gummies have fentanyl in them, the prosecutor will say, I tried to put the fentanyl in the gummies so Eric would have them. Stupid, I know, but that's what she's thinking. We will still test them, though. She, the defense attorney, she wants to link Eric, the victim, husband, decedent in this case. She, Sky, the attorney, wants to link Eric getting drugs and pills from Mexico, so we need some kind of connection. Her private investigator is doing some research on the ranch/cartel place that Eric would stay at. Here is what I'm thinking, but you have to talk to Ronnie. So all of that letter came across to me as instructions to build the defense that she and her defense attorney were discussing. It also talked about sneaking in crushed white strips, what to tell to who, and then fanciful stories about remember how this went down, remember how that went down. Since this letter was filed on the public docket, when this all came to light, the defense has been fighting over this letter and other items. In a fleet of litigation in the last week, which was leading up to what would have been the preliminary hearing, and then that was continued till June. I imagine it will be continued beyond that, seeing that it was continued for about a month, and now Kouri Richins is without, at the moment, a defense attorney. It's going to take some time to catch up on this case. It is a thorough docket. We are at almost 500 docketed items in this case. There's, I imagine, a massive file. And Kouri Richins is not just facing this criminal prosecution with the recent addition of charges. She also has a slew of civil lawsuits going on regarding the estate, regarding some of the financial trouble she was in with real estate and other things. We have gone over those on the YouTube channel if you wanted to dive all the way into this case and haven't yet. The prosecution also filed their brief regarding the preliminary hearing, which goes over their full theory of the case, including the February 14th seemingly fentanyl-laced sandwich that caused Eric, the victim in this case, to get very ill but not pass, and then Kouri Richins' request via text message to get stronger fentanyl, and then his subsequent poisoning on March 1st. All of that has been laid out in other filings and has been laid out again in their bench brief regarding the preliminary hearing, which is estimated to take 3 days. But today what we're looking at is all of the filings the defense made before the filing to get off the case. All in the same day, mind you. Everything was filed May 17th, and then the defense attorneys asked to get off the case, and that was granted on May 20th. So first, we are going to take a look at the motion to disqualify the prosecution, and then we are going to take a look at another attempt to have the walk the dog letter classified as an attorney-client privilege document. This is filed by the defense attorneys on May 17th. It's the motion to disqualify the prosecutor. Requested relief and grounds. The defendant respectfully moves this court to disqualify the prosecution from this case, and specifically Chief Prosecutor Brad Bloodworth. No, I did not make up that name. No, this is not a cartoon villain from DuckTales. Yes, the chief prosecutor's name is Brad Bloodworth. You cannot make up the things that happen in court, but they are asking to disqualify Brad Bloodworth due to his involvement in severe violations that compromise the integrity of adversarial fairness. It goes on to say Mr. Bloodworth and the prosecution's continued presence in this case poses a significant risk of further exacerbating these issues. And then they get into the relevant background, some of which is new to us. On December 11th, 2023, defense counsel emailed Summit County Attorney's Office the following, notifying them that she discovered Kouri's jail calls to defense counsel had been produced in discovery. This is an email between Jamie Thomas and the prosecutor's office stating, and they are quoting the letter here, I discovered this morning while reviewing discovery on Box that the jail has been listening to and recording Kouri's jail calls to Ramsey, and they are produced on Box. Do you know that this has been happening? Ramsey is clearly an attorney of record in the criminal case and the DCFS case, so I'm concerned. Those emails are attached as Exhibit A. We'll get there at the end. In the series of responses that followed, the DA, Brad Bloodworth, who is now lead counsel in this case, stated, quote, Ramsey refuses to register for and use the HomeWay app that shields attorney-client calls. His calls are, therefore, recorded as any other call. I can't imagine this is the first time that this has ever come up, because there is a different call-in procedure when lawyers are talking to clients, because if you're calling on the regular line, those are just routinely recorded. There is a separate system so that this doesn't happen. The pleading goes on and says Mr. Bloodworth goes on to state that the prosecution has been listening to at least a portion of the calls between Kouri and defense counsel since May 2023, and the entire prosecution team has been in possession of the calls for the entire period between May 2023 and December 2023. I'm interested to see what the emails say in full, and if what the emails say is we have been listening to her jail calls, and when it becomes clear that she is talking to Ramsey, we stop listening to those calls. But if those calls were on the other app, then they wouldn't be recorded. They say that Bloodworth further took the position that because defense counsel had not downloaded the HomeWave app, quote, it seems that Ramsey consented to the state monitoring the recordings. I mean, it's disclosed, but I'm sure that courts have dealt with this before, because attorney-client communications should not be in possession of the prosecution. But there is a automatic system that is automatically collecting those. If the prosecution hears that she is talking to her lawyer and then says, not this call, and cordons it off, that's different than if they're like, well, I mean, you called on the other line. It's interesting because I'm sure this comes up a lot. Defense counsel responded, quote, whether or not Ramsey uses the HomeWave app, attorney-client privilege calls are in the possession of the prosecution team, which is the concern. They say that defense counsel has never consented to the prosecution listening to recorded calls, and Kouri has not waived her attorney-client privilege, which is the point. Both Kouri and defense counsel believed that the calls between them were privileged and the state was not listening and did not have possession of them. Well, how do you think they're not getting recorded if you're not calling on the right line? It is an automated system. It is universally understood and accepted by attorneys across nearly every jurisdiction in the county that irrespective of whether defense counsel downloads an app or listens to a pre-recorded notification that a call would be recorded, that jail calls, or all calls for that matter, between defense counsel and their clients are privileged and confidential. They go on to say Summit County Attorney Margaret Olson immediately removed the calls from the discovery available to the prosecutors and placed them in quarantine box. It should be noted that Ms. Olson has been diligent in her efforts to remove other electronic communications that were missed by the privilege review team and notified defense counsel of same. They then get into a March 26, 2024 incident where defense counsel visited Kouri at the jail. She told the sergeant that she would need a paper pass as the defendant had notes relevant to the defense of her case to give to counsel. A paper pass meaning Kouri would give them to the sergeant would give them to the lawyers. It goes on to say that Sergeant Thomas is the same officer that conducted the searches on Kouri's cell, and they say, quote, improperly seized the walk the dog letter, they call it WTD letter, read it and turned it over to the DA's office. At the end of the visit, defense counsel asked the sergeant to facilitate the paper pass. Defense counsel notified the sergeant that the notebook contained privileged information, that the pages were clearly marked attorney-client Sky Lazaro at the top of every page, and further notified the sergeant that he could not read the pages and could not take the notebook, but that he should simply flip through to ensure nothing was stuck between the pages, which would be against the rules. It goes on to say that an argument ensued between defense counsel and the sergeant as to whether Kouri could give her counsel notes. Kouri should be able to give her counsel notes. The sergeant referenced that he was made aware of a prior problem, referencing the envelope and fictional manuscript that was ruled to be privileged attorney-client communication and work product. The manuscript that previously was said to be part of the walk the dog letter. Look, this has been outside of the presence of the public. If it's a manuscript, if it's a fictional manuscript, it's not privileged. Like, if a fictional work is not attorney-client privileged information. So there has to be something more there if it is deemed attorney-client information, which might mean it is her defense in story form, but I digress. It goes on to say that the sergeant took several minutes looking at every page of the notebook, during which defense counsel repeatedly told him he could not read the pages and was violating her client's constitutional rights. Again, each page was clearly marked attorney-client Sky Lazaro at the top. I imagine the argument from the DAs will be just because it says attorney-client doesn't mean it is. And given that they were concerned the walk the dog letter was witness tampering, though they did not charge it, I can understand how they got to the situation where the defense attorney is like, you can't look at my client's shit. And the jail is like, these aren't all attorney documents, but it is not up to the jail to make that determination. It goes on to say defense counsel suggests they speak to the judge about whether Kouri could give her counsel handwritten notes. This seems to be the appropriate remedy. If there's a problem with things being passed between the two, a judge needs to determine it, whether it's this judge or whether it's whatever the taint attorney was that looked at the other attorney-client information that's cordoned off separate from the judge in this case and the DA in this case that reviewed things to determine if they're attorney-client privilege. Someone can review it and make that determination. It said the sergeant, unsure of what to do, which is speculative, unless he said, I don't know what to do, left the attorney booth and returned with his captain and the DA. I am so confused how the DA is just at the jail. Are they all connected? Maybe it's connected to the courthouse and the DA's office. It says that Sergeant Thomas, his captain, and DA asked to speak to defense counsel outside the attorney booth. Counsel, and this is in bold, had her back against the wall in the corner while the three stood around her and intensely interrogated her about the contents of the notebook. This I do not love at all. To have two law enforcement officers and the DA, if it's this much of an issue, then the judge is going to have to determine it. Then it goes to the judge. Counsel repeatedly told them it was privileged and that they could not take it and they could not read it. Counsel repeatedly stated to the sergeant, his captain, and Bloodworth that they are violating her client's constitutional rights. The sergeant, his captain, and Bloodworth took the position that unless it was a legal document, Kouri could not give the notebook to her counsel. Counsel continued to explain the information in the notebook are notes material to her defense to assist counsel. Bloodworth questioned the sergeant as to the contents of the notebook, whether it appeared to be legal material. I mean, who gets to determine that? And whether it appeared to be related to the case. Bloodworth then asked the sergeant several times if he was sure to look at every page and whether he adequately inspected it to ensure it was legal material. The captain went on to suggest they all go through it again. Despite the intimidation and interrogation, defense counsel refused to allow the notebook to be inspected or taken from her client. Following this tense confrontation and interrogation of defense counsel, Bloodworth gave sergeant permission to allow defense counsel to take possession of the notebook. The defense subsequently requested all communications between the DA's office and the sheriff's office as it related to the case and asked that that include a call log. Bloodworth represented to counsel there were no communications. A call log was never produced. Sergeant Thomas's statements and Bloodworth's appearance at the jail with regard to the notebook issue would indicate there was at least one call from the sheriff's office to the prosecutor's office. Well, some of that might also be work product. The defense goes on to cite case law saying that the ultimate decision to grant or deny a motion to disqualify counsel is within the trial court's discretion, and disqualification of a prosecutor is a remedy within the court's authority to maintain the fairness of the proceedings. This measure is not only appropriate but necessary when the prosecution's actions have compromised a defendant's right to fair trial. And that's what they're arguing here. They're arguing that the prosecutor violated the defendant's Sixth Amendment right to effective counsel and should be disqualified because of that interference. And they went on to quote Strickland v. Washington, saying that the Sixth Amendment right extends beyond merely having legal representation. It encompasses the right to effective assistance of counsel. Everyone, I'm sorry for all of you that have studied law to talk about Strickland v. Washington, but here you go. The podcast counts as a CLE now. Write it down as part of your self-study. They say, quoting Strickland specifically, it ensures a defendant's right to be assisted by an attorney who plays the role necessary to ensure that the trial is fair. They go on to say any intrusion into this confidential attorney-client relationship constitutes a direct violation of the defendant's Sixth Amendment right. They go on to argue that in certain Sixth Amendment contexts, prejudice is presumed by the action. So they're saying they don't have to prove that what the DA has done caused prejudice. They just have to show, they are arguing, that the interference is enough that prejudice can be presumed. Again, quoting Strickland, saying, because we believe that a prosecutor's intentional intrusion into the attorney-client relationship constitutes a direct interference with the Sixth Amendment rights of a defendant, and because a fair adversary proceeding is a fundamental right secured by the Sixth and 14th Amendments, we believe that absent a countervailing state interest, such an intrusion must constitute a per se violation of the Sixth Amendment. Now, I imagine the state is going to argue that security in the jails is a countervailing state interest, so the automatic recording system that allows for jail calls between an attorney and a client on a separate app that isn't recorded, and searching things from this defendant when there have already been, as they put it, issues with this defendant. They're going to argue that that is a state interest. The defense is arguing that this is intrusion into the attorney-client relationship. They go on to argue that the court should exercise its discretion and disqualify the prosecution, and that the court has the discretion to do that this case has been rife with violations since the outset, and that despite the court's denial of defendant's motion to dismiss, there remains an ongoing problem in the case. Mr. Bloodworth listened to at least a portion of Kouri's calls with defense counsel from May to December. It says worse, Mr. Bloodworth justified this behavior, stating it was defense counsel's fault for failing to download an app. This was his entire justification for violating attorney-client confidentiality. It goes on to say that the court has previously ruled that the envelope found in Kouri's jail cell labeled attorney-client privilege containing the walk the dog letter was privileged. However, video evidence of the cell search reveals that officers meticulously examined each and every page of the envelope and read its contents. Footnote 4 says the defense understands that there may be a factual dispute regarding the location where the letter was found. It goes on to say that notably the same sergeant involved in this search had ongoing communications with Mr. Bloodworth. It is clear from the sergeant's statements to defense counsel that he's privy to information about the case, indicating that he and Bloodworth have discussed the case, or that he listens to me, because I have talked about all of this at length. And the issues with the walk the dog letter have come up in public filings. I'm just saying. I don't think it necessarily indicates that they've discussed the case, though it wouldn't be unusual for the DA to discuss a case with a member of law enforcement. But I digress. It goes on to say Sergeant Thomas now has information related to the defense strategy from the notebook that he reviewed. I mean, the walk the dog letter also seems to have defense strategy. They go on to allege, quote, it appears the two are effectively working in concert to violate the defendant's Sixth Amendment rights. It goes on to say, while the court should at minimum disqualify Mr. Bloodworth from this case, every attorney in the Summit County District Attorney's Office where Bloodworth works is assigned to this case. Really? And has access to the cloud-based box folder containing all the quote-unquote evidence, discovery, and other sensitive information about the case. They say given the office's small size and the close working quarters of each of the attorneys, there's a high likelihood that each attorney in the office has had meaningful access to the evidence and sensitive information and even been privy to privileged communications. Although typically only one attorney from an office should be conflicted out of a case when issues arise, this situation is unique. All of the prosecution's attorneys had access to the same discovery materials, even though access to the attorney-client communications was eventually removed. There was a period during which the entire office had access. With only a handful of attorneys in the office, the risk of widespread contamination is significant. They say, Kouri, this is a quote from the pleading, Kouri pleads with this court to be vigilant in protecting the rights of the accused and ensuring that all parties adhere to the highest ethical standards. Allowing the prosecution to continue in this case after violating the defendant's right to effective assistance of counsel and intruding on confidential and protected information would undermine public confidence in the criminal justice system and erode the foundational principles of fairness and due process. And attached are a number of the emails that were written about in the motion that we're going to go over because you know how I love an email. This seems to start on December 11th, 2023 at 2:49 p.m. Summit County team, I discovered this morning while reviewing discovery on Box that the jail has been listening to and recording Kouri's jail calls to Ramsey, and they are produced on Box. Did you know that this has been happening? Ramsey is clearly an attorney of record in the criminal case and the DCFS case, so I'm concerned. And that is from Jamie Thomas from their law firm. The response from Margaret Olson, Summit County attorney, is what? No! Exclamation point. The response then to all of the groups is from later that afternoon. Jamie, Ramsey refuses to register for and use the HomeWay app that shields attorney-client calls. His calls are therefore recorded as any other call. He is well aware of this. We do not listen to his calls. He identifies himself within the first few seconds of the call, and we stop listening. We prefer that he would use the HomeWave app. I imagine the prosecution is going to be ruffled by the insinuation that they were listening to these calls beyond just identifying him on the call and then cordoning it out. The next email is back from the defense office saying whether or not Ramsey uses the HomeWave app, attorney-client privilege calls are in the possession of the prosecution team, which is the concern, right? Because they're automatically recorded and turned over as like part of an ongoing mechanical process. It says also in a prior call, you mentioned Ramsey was aware of Kouri wanting to change lead attorneys. Can you direct us to which call you were referring to? Thanks. It then goes on with a list of calls. We're going through all of this. This is from December 12th. Good morning, Jamie. Since May, Ramsey has deliberately refused to use the HomeWave app. According to Kouri, Ramsey thinks the app somehow bugs his phone. These must be from Kouri's other jail calls. Like she's referring back to the situation in other calls. Also, according to Kouri, Ramsey knows that in refusing to use the app, the state maintains records of the calls. Accordingly, it seems that Ramsey consented to the state maintaining their recordings. Moreover, the state has transparently been providing these recording and discovery for nearly 6 months. The defense has not raised any concern during this time. Therefore, it seems that the defense has ratified the state's approach and waived any current concern. I mean, I don't know about that. Again, the state has not listened to these recordings and prefers that Ramsey use the HomeWave app. It is unclear why the defense is suddenly concerned. Below are all the call details and the upshot of the calls I was referring to when I said Ramsey was aware that Kouri wanted to replace Sky as lead. We're available to discuss this today if interested. Regards, Brad. And then we've got a list of phone calls with summaries. Let's. From November 18th, 2023, voice call with Renee. Kouri did not like Ramsey at first, but now he is her favorite on the team. Ramsey wrote 90% of the filings. 11:19, voice call with Ronnie. Kouri is done being here. I'm assuming that means jail. Sky needs to get her the fuck out of here. Kouri considering firing Sky and putting Ramsey in charge. That's not happening, especially with the additional charges in the indictment. 11/20/2023, video call with Lisa, recap of call with Sky. Family, except for DJ, is done with Sky. If you recap the call you had with your attorney with a third party, the contents of the call with the attorney are no longer privileged because that information has now been shared. I don't think that means the prosecution gets to go listen to the calls with Sky, and I don't think they have access to those because it seems that Sky is using the proper apps to call her clients. But if she's recapping her conversation with her attorney, with her mom over a recorded call, that's no longer private. Oh, but wait, there's more. Video call with Lisa, continuation of above. Lisa complains that Sky has no trial experience. I don't know if that's true. Sky's been actually, personal opinion, I've really liked Sky's demeanor in court, and I think she's handled this case well, but I am not the client. My opinion is irrelevant. But also, I'm surprised Sky didn't fire Kouri over the walk the dog letter. So, here we are. Also, your attorney is going to listen to these calls. You don't shit talk your attorney on recorded jail calls with your family members. It's just, that is going to intrude in the attorney-client relationship. But now this is all public because it's part of their filing right before they moved to leave the case and have now done so. It goes on to say this call with Lisa discusses putting Jamie in charge. They are mouthing words so that we can't hear. Video call. Sky can't present at trial. She, quote, don't have it. Sky's ego is taking over. The writing is on the wall. All the legal analysts are saying the same thing about Sky as Lisa and Ronnie. I would like to be excluded from this conversation, by the way. Sky, I'm excluded from this conversation. I am not part of that conversation. It goes on. Oh God, it gets worse. Emily, you should read these before you podcast them. We're in it now, folks. We're in it now. Oh, I'd be so mad. Video call with Lisa. Continuation of above. Kouri's particularly angry. Kouri referred to Sky as a dumb bitch. Lisa Zillowed Sky's house to see its value. More mouthing and whispering to avoid being heard. Did Sky not listen to these? Because why are we just getting to May with you getting off the case? Because what you don't need is people Zillowing your home. Oh, good. We're getting right to Thanksgiving. November 24th, 2023, voice call with Ronnie. Kouri is upset that Sky did not visit and not answering her calls. Ronnie advised Kouri to dump Sky. Kouri says if she does not hear from Sky over the weekend, she is moving to Plan B on Monday. November 27th, video call with Lisa discussing replacing Sky with Ramsey or Jamie. Video call with Renee later that morning. Kouri spoke with Ramsey about replacing Sky. Ramsey did not want to discuss on the phone. He will visit Thursday. That makes sense. Video call with Lisa. Ramsey taken off guard when Kouri said she wanted to have someone else at the law firm take the lead. Voice call with Ronnie. Kouri informs Ronnie that she informed Ramsey that she wants Sky as lead. So the prosecution's like, oh, well, here's a summary of the shit talking and the calls. If you want to go listen to them, the prosecution timestamped them for the defense. And didn't miss words because they definitely put Sky needs to get the fuck out of here. And Kouri calling Sky a dumb bitch. I'm just going to point out that Kouri's the one that texted asking for stronger fentanyl after the victim did not pass from a sandwich that appeared to make him incredibly ill from fentanyl. So I do appreciate the defense spilling all of the tea in their attachments to the motion to disqualify the prosecution. But wait, there's more. Thank you to today's sponsor, Shopify, which powers the Lomi shop, which is where you can get your Lomi oil slick tumbler on sale for a few more days. When I built the Lomi shop to bring you all of the Lomi merch goodness, I immediately went to Shopify because it's so easy. And everyone I know that sells anything in e-commerce uses Shopify. From crafts and wreaths to courses to nail polishes to makeup, Shopify powers 10% of all e-commerce in the US. And if you're selling locally or in store, Shopify has you covered for that too. They are the global e-commerce platform that helps at every stage of your business, from just launching to passing 1 million orders. And Shopify has the internet's best converting checkout, 36% better on average. I think that's because the checkout process is just so easy and secure. And if you're ever stuck on what you need, Shopify's award-winning help is there to support your success every step of the way. It's no wonder that businesses that grow with Shopify. And if you're ready to try it for yourself today, you can sign up for a $1 per month trial period at shopify.com/Lawnerd. Remember, that's all lowercase. Go to shopify.com/Lawnerd now to grow your business no matter what stage you're in, and you'll start hearing this sound soon. Let's get back to today's podcast. After their attempt to get the walk the dog letter designated as attorney-client privileged information, the defense is attempting again to have the walk the dog letter designated as attorney-client privileged communication and to be removed from the public docket and suppressed. Relief requested. They say the state improperly seized the walk the dog letter from the defendant's cell during its search for letter number 2. The state did not conduct any privilege review of the walk the dog letter, instead filing it on the public docket shortly after it was found. Defendant never disclosed the walk the dog letter to anyone. The state has argued the walk the dog letter was part of the fictional manuscript in previous filings. The court ruled the manuscript was attorney-client communication and attorney work product. Defendant seeks an order from this court designating the walk the dog letter as attorney-client communication and attorney work product and therefore suppressing it. That letter, to me, is clearly written to Kouri Richins' mom, not to her attorney. So it is disclosing conversations between her and her attorney to a third party. But they are arguing that that was never disclosed, that a different letter is the one that was disclosed on the jail call. The full weight of the defense's motion to designate that walk the dog letter as attorney-client privilege is that it was found with the rest of the manuscript that was then designated privileged, and that the no contact orders requested by the state were denied by the court. But wait, there's more from the same fleet of filings. It seems that this would have been the last one filed, and that is the motion to withdraw and appoint new counsel. This is for the entire law firm, RQN, which is Ray, Quinney, and Neberker. I think I got that right. Is hereby providing notice that it has a professional duty to withdraw from its current representation of the defendant, Kouri Richins. The ethical mandate for withdrawal results from an irreconcilable and non-waivable situation. It first emerged from the civil cases in which the firm has been representing Ms. Richins, but it is imputed to the firm as a whole and thus requires the firm to withdraw from its representation of the defendant in this criminal proceeding. The matter emerged after the hearing held Wednesday, May 15th. The court and opposing counsel in the civil matters are being notified today of the firm's withdrawal. To properly safeguard the defendant's constitutional rights, this court should immediately grant the firm's motion to withdraw and should immediately appoint new counsel to continue the vigorous defense of the criminal charges against Ms. Richins. And that is signed Sky Lazaro on May 17th. There was a brief hearing on that, of course, closed to the public. The prosecutor would not have been at that hearing either that was allowing the defense to withdraw. There had been motions on the docket for a victim's representative of those hearings. Those were denied. When it comes to matters of attorney-client relationships, no one else is present. It is the judge and it is the defense attorney and the defendant. I have been in court where the defendant starts yelling at the judge I want a new lawyer. My lawyer's doing this. And we're like, yep, we're out. We're leaving. We're going to go. Your Honor, we're going to go. Y'all are going to have to sort this out. It sounds like the defendant's about to make a motion to file his attorney, and he's starting to get into all of the things. We'll be back. It's not an uncommon thing. It's different when the defense counsel is the one making the motion to withdraw, but these were privately retained defense attorneys, and they were working on the civil cases, of which there are many. So not only was the walk the dog letter not enough, but the trying to get her mother to sneak in crust white strips and the jail calls, well, apparently Kouri Richins is calling her attorney a dumb bitch, were not what caused this. There was other conflict that arose, and I'm going to be keeping an eye on the civil matters to see if anything unusual pops up at those filings that might give a hint of what happened. So who knows what it is? But it seems to me that this is a matter that goes beyond maybe payment, and that it is something that has disqualified the entire firm. So all those phone calls where Kouri was asking for another member of the firm to be lead counsel isn't going to happen in the criminal case. The entire firm has already been withdrawn, and I imagine that will happen fairly quickly in the civil cases as well. And Kouri Richins will need a bunch of new attorneys, because if she's appointed counsel in the criminal matters, they are not going to represent the civil matters. What the public defender's office does not have time for is the panoply of civil lawsuits that Kouri Richins is in, some of which she has filed and some of which they have filed. Some of them are stayed because of the pending criminal action, but Kouri Richins sued her late husband's estate, and they sued her and her mother. So all of this is going to continue to be wild, but I imagine what we'll see from here is that preliminary hearing in June getting set out quite a bit longer. So if Kouri's goal was to have somebody get her the fuck out of custody, remember, this is the woman that was Googling luxury prisons for rich people, it's going to be a minute with this one. So with all of that, maybe Kouri's paramour will help her find a new attorney, because she is going to need at least 2, if not more. And with that, I hope this kept you in the loop of the other cases that we have going on. And there is a lot of motion going on in a few of the other cases that I have been following. And I am trying to keep up with the filings and keep up with everything going on in Massachusetts. So hear ye, law nerd. Thank you for being here. Thank you for being a law nerd. Thank you for downloading the Law Nerd app and staying tuned to everything we're doing. Say it with me. May your Wi-Fi be strong. We're strong enough to handle these court days in Massachusetts. They are long days. May your snacks and toilet paper be plentiful. May your family be well. And may the odds be ever in your favor. I will see you in the next one. You can stay up to date with everything I'm covering on our free iOS and Android app at lawnerdapp.com, or search your app store for Law Nerd. And you can also follow me on social media at the Emily D. Baker. Remember, I stream on YouTube on Tuesdays and Thursdays. I recap all of that for you in quick bits on Monday. And of course, The Emily Show drops on Wednesdays. Thanks for being a Law Nerd.